Hi guys, welcome back to my channel. This is Batok with Ola. My name is Mujola Olua. Thank you so much for stopping by once again. If you haven't subscribed to the channel, please do well to click the subscribe button, and you can as well, turn on notifications so that whenever I post a new video, you will see. Today I want to talk about injunctions. Injunctions are applications made to the court pending the determination of a matter. Injunctions are, applications that you make by way of emotion. I've told you on this channel before that emotion is a prayer before the court, asking the court to compel an action or to restrain an action. It is usually brought by a person called the applicant against another party called the respondent, and the respondent also has the chance to respond to the motion. So injunctions are brought by way of motions. There are two types of injunctions. We have interim injunctions and interlocutory injunctions. Today I really want to focus on interlocutory injunctions by way of Mareva injunction, Anton Piller injunction, and Interpleader injunctions. Those three injunctions are very important, and I'm going to be explaining them in brief and in detail as much as I can combine those two extremes. But like I said, there are two types of injunctions. There is interim and there's interlocutory. So the differences are that both of them are to preserve the status quo in a matter usually. But for interim, it is used or brought in cases of extreme urgency, while for interlocutory, it might not be as urgent, but both of them are brought to preserve the rest or to maintain status quo in a matter, before the decision is made. Another thing is that interim injunction is brought by way of ex parte motion. It's so urgent that you do not have the time to put the other party on notice, so you can come before the court ex parte. But interlocutory injunctions have to be brought on notice by way of motion on notice. Yeah, that's another difference. And another difference is that interim injunctions last, till a certain period. So the court could say, for 7 days or for 2 weeks or thereabouts. So they last for a certain period. They do not have to last until the determination of the suit. But interlocutory injunctions last till the determination of the suit, till the determination of, the matter in court. Interlocutory injunctions last as such. Before the court will grant an injunction, there are certain factors it will consider, and those factors were well established and restated in the case of Obeya Memorial Hospital versus Attorney General of the Federation. And I'm just going to be pointing out those factors in brief before we go into the three interlocutory injunctions that we really want to talk about today in detail. The first is that there must be a legal right in existence. That is, there must be a legal right capable of being protected by the grant of that injunction before the court will hear or grant an interlocutory injunction. For instance, if you're bringing an interlocutory injunction, asking a party to cease construction on a building pending the determination of who owns the valid title to that land or property in question, there must be an existing legal right. That is, the right to ownership, which is to be decided by the court, must be in existence. It must be, a property that is capable of being owned by either of the parties. And then, so that's the existing legal right. So one, there must be an existing legal right before the court will even consider your interlocutory injunction or any injunction at all. The second factor the court will consider is that there must be a substantial issue to be considered. That is, the application is not a frivolous one. You're not just trying to mess with the court or mess with the other party by bringing the application for injunction. Yes, there must be a substantial issue at hand. There must be a substantial issue to be tried by the court. The court will look at that. The third thing is the balance of convenience. The court will consider the balance of convenience. That is it more convenient for that party to hold on, the respondent to hold on or refrain from doing what they are doing now? Or will it be more convenient, for them to continue what they are doing, and then after the decision has been reached and the judgment is now against them, for them to reverse what they are doing now? So the court will look at the balance of convenience, which is more convenient, to grant this application now and stop them from doing what they are doing, or to compel them to do certain things, or to just let things continue the way they are until the determination of the suit, and then compel them to restore whatever it is they've done back to status quo, or to correct whatever damage they've done. The court will look at it, the balance of convenience. On whom is the balance of convenience? Is it better, is it easier for you, the applicant, to manage the damage, to get a reparation for whatever damage they might have caused, or is it more convenient to just ask them to stop whatever they are doing now, so that the damage will be minimal by the time the matter is decided? So the third thing the court will look at before granting an injunction, especially an interlocutory injunction, is the balance of convenience. On whose side does the balance weigh more or swerve more? The fourth thing that the court will consider is irreparable damage. Is similar to balance of convenience. So the court will look at it. If we refuse to grant this injunction, will the damage done at the end of the matter before we reach a judgment, will it be irreparable, or will an award of damages against whoever has caused some damage, that award, will it suffice for the person, the victim of the damage? So is it better? Which one will suffice? Is it awarding this injunction to prevent irreparable damage, or waiting for the damage to have been done? So the courts will look at that. They are similar, but they're not the same. Balance of convenience and irreparable damage. The court will look at it. Will this injunction, the grant of it, will it prevent irreparable damage for the applicant? If yes, the court will grant it. But if no, if the court refuses it and some damages are done, there will be an award of damages that would actually suffice, for or commensurate for or with the damage that's been done. The court might not grant it. So I hope you understand. The court will look at the likelihood of irreparable damage in granting an injunction. The fifth thing that the court will look at is the conduct of the parties in the matter. Is their conduct reprehensible, or is their conduct responsible? Are they showing regard for the court? Are they showing responsibility regarding the case at hand? Do they understand that someone else's rights, are being affected or compromised, or are they just acting, without any care, not caring whose ox is God? The court will look at it, because it comes to equity must come with clean hands. So the court will look at it. You that you are bringing the application, are your hands clean? Have you acted in any reprehensible way in this matter, or before this matter, in any way regarding this matter, before we can grant this injunction? The sixth and final thing that the court will look at, as established in Obeya Memorial Hospital and AGF, is undertaking to pay damages. So for injunctions, the party bringing the application must undertake to pay damages. That is, if it is found that the court should not have granted this injunction, and it works hardship on the other party unnecessarily, I undertake to pay any damages involved. I undertake to pay for whatever injury might have been incurred by the other party because they were complying with this injunction, or because I allowed or made the court grant the injunction wrongfully, unduly, or unnecessarily. So the court will look at these 6 things, and before it can decide if it should grant an application for injunction, whether interim or interlocutory, or not. So let's now go to the 3 interlocutory injunctions that we want to look at today. Like I said, interlocutory injunctions are brought before the court. Applications for interlocutory injunctions are brought before the court, to ask the court to command the doing of an act, or the restraint from the doing of an act, pending the determination of a suit. That means that a case must have been in court. You cannot commence an action by an interlocutory injunction. There must be a subsisting matter in court, before the court, before you can now bring an interlocutory injunction in that same matter, asking the court to command or to restrain the other party from doing one thing or the other, pending the final judgment in the matter, pending the determination of that matter. So we have a few types of interlocutory injunctions, but I really want to talk about Mareva, Anton Piller, and Interpleader injunctions. Mareva injunctions now. Mareva injunction is an injunction that is brought by the applicant or the plaintiff or the claimant in a matter, asking the court to restrain, the other party, the respondent, the defendant, from disposing of their assets, pending the determination of the suit. So let me give you a little example. For instance, now you're owing me a debt. Now you're a company, you're owing me a debt. Perhaps you're an international company, but you have a Nigerian bank account. I can bring an injunction against you, asking the court to restrain you from moving your monies from your Nigerian bank account, pending the determination of the suit, so that if the suit finally goes in my favor and you have to pay me, from that bank account, it will not be found that there's no money there as an excuse for not settling your judgment. So I hope you understand. So Mareva injunction is brought against a party in a suit that is probably not within the country, but that has assets within the country, preventing them from disposing of those assets outside of the country or within the country, so that when judgment is given and you have to levy execution against those assets, they will still be in existence. It will not be that the assets are no longer in existence when it's time to levy judgment. So this injunction is used to ensure that justice is done, or to forestall defeating justice eventually, even after judgment might have been passed. Mareva injunction is brought by an ex parte motion, application by ex parte motion before the court, and it was established in the case of Mareva Compania Navarra SA and International Bulk Carriers Limited. It's a 1975 case. So that's the case that established this injunction as it's like that's the locus classicus. Like any other motion or any other injunction, application for injunction, when you bring an application for a Mareva injunction, you have to prove to the court that actually there's a subject matter, there's a valid and a subsisting matter before the court, that there's actually a substantial matter that the court can decide upon, that the respondent actually has assets within the jurisdiction of the court, and that you have reasons to believe that if the court does not restrain them or grant that injunction, they might move those assets outside of the jurisdiction of the court or dispose of them such that execution cannot be levied against them when the judgment is finally given against them. So, and you have to prove all those things before the court can grant a Mareva injunction against the defendant or respondent in that matter. And of course, you have to show or prove to the court that the defendant is a foreigner. So there's likelihood of them moving their assets outside of the country, outside of jurisdiction, or disposing of it within jurisdiction before the matter is decided. There's a Nigerian case as well, Tominu versus Ocean Steamship. So that's a Nigerian case in support of Mareva injunction. And as you're bringing this injunction, you also have to make full disclosure of all the assets that the defendant has within the jurisdiction of the court. That means that you have to know these assets. And of course, you have to also prove all those legs of factors that the court will consider before granting an interlocutory injunction. Once you're able to prove that to the court, you will likely win the court over on the strength of your case. Yes, you will likely win on the strength of your case once you're able to prove all those things. So that's Mareva injunction. Let's go to Antonpillar injunction. Antonpillar injunction was established in the case of Antonpillar KG and Manufacturing Processes Limited and others. Antonpillar KG and Manufacturing Processes Limited and others. Antonpillar injunction was established in the case of Antonpillar KG and Manufacturing Processes Limited and others. It's a 1976 case. Another case that establishes Antonpillar injunction is Ferredo Limited and Unibros. It's a 1980 case. So Antonpillar injunction is an injunction brought to the court, asking the court to compel the defendant to allow the plaintiff enter into his possession to inspect some things, materials, evidence that might be prejudicial to the trial if disposed of or destroyed by the defendant. Usually it's brought in cases of intellectual property malpractices or infringement. For instance, in the Antonpillar KG itself, an employee was selling the trademark of his company, his employer, to a rival company. So the Antonpillar injunction, when he was sued, the Antonpillar injunction was brought, asking the court to mandate him to allow the applicant, that is the claimant or his solicitor, to enter into his premises, whether it's business premises or wherever it is that he has kept those subjects of infringement or objects of infringement, to allow them enter and inspect those things, inspect those things. And it's brought when there's a likelihood that, the defendant might destroy those material evidence, which might be useful and which might be instrumental to the winning of the case and justice being done in that case for the claimant. So it's more like a search warrant, but in this case, it's not an injunction or an order of court allowing the claimant to enter into the defendant's premises without the defendant's permission. No, rather it's actually addressed to the defendant. That is, the court is compelling you as a defendant in this matter to allow the claimant or a solicitor to enter into your premises to search and inspect things that are objects of this trial, things that will likely support their case. For instance, if it's like a breach of copyright, for instance, and maybe someone has been accused of, mass producing CDs and selling against the copy, which is a copyright infringement and a piracy matter, for instance, you can bring an Antonpillar injunction asking the court to compel such person to allow your solicitor enter their premises to recover those CDs, which you can now bring as evidence before the court to show the court that indeed they had mass produced these things and they were selling it. Now you bring those things where you bring this injunction when you're afraid, or there's a chance that the defendant would destroy those things, which is your evidence before the court, which is proof that they have actually infringed on your right, on your intellectual property. So if there's a likelihood that they would actually destroy those things, you can bring an Antonpillar injunction to compel them, to allow you enter, inspect, or probably retrieve those things for as evidence before the court. So the same thing happened in Ferrido Limited and Unibros. The court established the fact that, when there's a likelihood of the destruction of such things, you can bring an Antonpillar injunction actually. So that's Antonpillar injunction. So when you're bringing an Antonpillar injunction, you come by way of an ex parte motion. You have to be discreet about it, because you can imagine, letting the other party know that I'm going to apply to the court to allow me enter your premises, allow you to compel you to open your premises to me, to enable me enter into your premises and inspect and probably retrieve, objects that will be instrumental and favorable to my own case in your custody. You know what they might do. They might even go on and destroy it before the motion is heard before the court. So it's a very discreet kind of motion. It's usually heard in the judge's chamber, and because the Federal High Court has jurisdiction over copyright issues, where the issue we're talking about is a copyright infringement matter, you have to make this application to the Federal High Court. So it's a very discreet injunction, and you need to prove all those legs of injunctions before the court. And most importantly, two things. You have to prove that, one, the defendant actually has those things in their custody. You are sure, you're not just guessing and hoping that maybe when the court grants the order, you might actually find those things in their custody. You have to be sure. And second is that you have to undertake to pay for damages. Should it be that it was a fruitless exercise and the court should not have granted that order, you have to indemnify, the other party. You have to undertake to pay damages, So those things must be proven. And once it's done and the court believes you, the court will grant that injunction. Now let's go to Interpleader injunctions. Interpleader injunctions is a more curious, type of injunction, because it can come from two sides, and I'm going to explain why. An interpleader injunction is also called interpleader summons, and it's a kind of application that you bring before the courts for a grant of a relief as such. For instance, you're owing a debt, and two rival, creditors are laying claims to that debt, and now you are at a loss. If I pay to A, B will say that I haven't paid the debt. If I pay to B, A would say that I haven't paid the debt. So what I'll do is that I'll apply to the court to compel A and B to come and defend themselves before the court, to prove to the court that one of them, either of them, is the rightful creditor that I should pay to. And I'm making that application because I don't want to pay twice, and I don't want to pay to the wrong person. So that's essentially what an interpleader summons is. It's an application to the court compelling two rival claimants or creditors, maybe judgment creditors, debt creditors, or what have you, to come and prove that either of them is the rightful person, the rightful creditor, before a debtor will pay to them. It can be brought by a private person, and it can be brought by a court sheriff or by the stakeholder. When it's brought by the stakeholder, it's called stakeholder interpleader, but when it's brought by the sheriff, it's called sheriff interpleader. So the stakeholder could be a debtor, like I said. It could be someone that is at a loss. For instance, if a landlord has died, and maybe his estate is being governed by customary law, and maybe 2 or 3 brothers and sisters are fighting over, oh, I'm the one the tenants should pay rent to now, I'm the one the tenants should pay rent to now. So a tenant who is a stakeholder now, can bring a stakeholder interpleader before the court application, asking the court to compel these people these siblings, come to court, come and defend your title. Let me know who is my rightful landlord that I should pay to, because I don't want to pay twice and I don't want to pay to the wrong person. So they would come defend themselves. When the court has decided who is the rightful landlord, I will then pay to that person. So that's essentially what a stakeholder interpleader is about. For a sheriff's interpleader, however, the main issue is that the court sheriff is trying to execute court judgment on a property, for instance, and a third party is showing up and saying that the property does not belong to the judgment debtor, rather it belongs to them. So that application is brought before the court for the court to compel, the third party and the judgment creditor to come before the court to show cause as to why, judgment should not be executed against that property. So essentially, that third party is coming to court to prove that this property does not belong to the judgment debtor. It belongs to me, so you can't levy execution against it. And the judgment creditor is coming to prove that I'm entitled to execution being levied against this property in my favor, because I actually have court judgment. So when they both approve their matters or their cases before the court will decide if the sheriff should go ahead and execute judgment and levy execution against that property or not, or release it to the third party who is laying claims to it. After they might have proven their cases before the court will decide who has the property and what should be done about it. So that's a sheriff's interpleader. And it's brought so that the sheriff will not execute judgment, wrongfully, and so that, a third party, an innocent third party, would not suffer, after probably being mistaken or being fraudulent, or his property being fraudulently misrepresented, by the judgment debtor as is or as. So I hope that you understand that. That's essentially what the sheriff's interpleader is about, and it was initiated in the case of 1991 case, the Nigerian case of Injunctions and Injunctions and Onuigbo. It's a 1991 case. That's the case that explains the sheriff's interpleader, expressly and better. It's essentially, a proceeding brought to determine whether the property against which execution is about to be levied actually belongs to the judgment creditor, and if the levying should be carried on with. So very important before the court will now execute, judgment against the wrong property. That's essentially what a sheriff's interpleader is about, and it's brought by way of originating summons. As opposed to ex parte motion, the application for a sheriff's interpleader is brought by way of originating summons. The locus classicus for this case is Diplock and Hammond. It's an 1854 case, and it established, some of the factors or some of the things that, an applicant must prove. He must prove that he's actually not colluding with any of those claimants that are coming to prove themselves before the court, and he's coming also to prove that he has no specific or special interest in the matter, except for maybe charges and costs, of the application. He has no specific interest. He has no ulterior motive for bringing that application before the court. And thirdly, he has to prove that he's actually willing to pay or transfer the subject matter, that is the judgment settlement, or the debt sum, into the court's coffers, or into the coffers of whoever the court decides is the rightful creditor. It's instituted by way of originating summons, but if there's a pending case, before the court, you can bring it by way of motion into the case, or by way of originating motion, you can bring it into that matter. So when the court has heard and decided, the court will decide if to add any of the claimants as a defendant or as a claimant, a co-claimant in the pending suit before it. So that's essentially what an interpleader summons is all about. In this video, we've talked about, injunctions. We've talked about interim injunctions, interlocutory injunctions, and the differences between them, how they are brought to court, and all of that. And then we've looked at three types of interlocutory injunctions. We've looked at Mareva injunction, Anton Piller injunction, and we've looked at, interpleader summons, which could be stakeholder interpleader or sheriff's interpleader. We have looked at the decisions that the court will arrive at, and how a party bringing any of these injunctions will prove his case before the court. We've talked about what the decisions that the court will make upon the grant of these injunctions, and how a party bringing any application for any of these injunctions would prove his case before the court. I hope that you've learned one or two things in this episode. I will always see you in my very next episode. Don't forget to subscribe to those.